I have in the file, there was a motion to void and seal for sanctions. And that was in the file this morning, but then at lunch, I got the respond to defendant's motion to seal and for sanctions, which I have not had the opportunity to look at. Has everyone received their filings?
I have.
You all have all received? Okay, all right. So we'll be, of course, hearing oral arguments on the matter. Would the parties please announce?
Yes, Rebecca Cotton for Dequita Coleman.
All right.
John Benz and Emma Blackner for the petitioner, Your Honor, and we want to go on to record that we're reserving our right to make a future request for CR 11 sanctions against Ms. Cotton.
Very good. Are there any other preliminary matters, Ms. Cotton?
Judge, just that before we can proceed on the CR 11 motion that we filed, we do need a final order in the case. So I believe Mr. Benz already mentioned that he's filed a voluntary dismissal. If the court wants to go ahead and enter that.
Yes, and that was on 3-4. Comes plaintiff by counsel and hereby moves this court to dismiss the forcible detainer action in 25C 3849 without prejudice, the court being otherwise sufficiently advised. And are you gonna, we had a motion earlier for with prejudice. Are you gonna be making a motion with, or are you satisfied with the without prejudice?
I'm satisfied
Okay.
with Mr. Benz's voluntary
All right.
dismissal.
All right, very good. It's hereby ordered and adjudged that the forcible detainer action in said case is going to be dismissed without prejudice. This is a final and appealable order, for which execution may begin forthwith if there is no just cause for delay. And I'm putting my little electronic signature there. So now we can move on. And so the next matter before me is the motion to void and seal. And then there's a separate and for sanctions, right?
Yes.
All right, very good. Ms. Cotton?
Judge, so I believe that, both parties have had the opportunity to file a written motion and response on this issue with the court. You've already indicated that you haven't had opportunity to read Mr. Benz's response. But if Mr. Benz is okay with it, I propose that similar to that earlier case with Connor, that you take it under submission and then allow us to do brief oral arguments.
We object, Your Honor. We want it resolved today because we believe Ms. Cotton's motions have no relevant standing and are improperly made and subject to her to sanctions.
Your objection is noted. However, as I mentioned, that I got several findings at lunch today, so certainly did not have time to read them. I apologize if it caused any undue.
But this case has already been delayed like 3 weeks, Your Honor.
Okay, the dismissal has been ordered, the voluntary dismissal, but I need time to hear oral arguments. It may be possible that with the oral arguments, maybe I can make a decision. I will certainly do my best to make a decision based on your oral arguments, but I am going to ask to reserve my right to take it under submission. Let's begin with Ms. Cotton.
So Judge, in order for the court to fully consider my arguments on the CR 11 motion, we would be requesting that the court enter on the record the exhibits filed with our notice of defense.
We have to object to that, Your Honor. When Ms. Cotton filed those, she violated CR 703.
I'm not finished.
You have the right to object, Ms. Cotton, because you're trying to enter documents that actually subject you to sanctions that are mandatory.
Judge, I'd appreciate it if Mr. Benz directs to you.
All right, Your Honor. Ms. Cotton, in violation of 703, is now subjected herself to mandatory sanctions from the court because she failed to redact her client's social security number and date of birth from the record when making her exhibits. 703.7 is clear that that document has to be stricken from the record, and Ms. Cotton is now subject to the contempt orders of the court.
All right, Ms. Cotton.
Judge,
Objection noted.
I wasn't able to finish
Yes, ma'am.
what I was asking you to do.
Yes, ma'am.
But I do agree that the last page of the lease, which includes Ms. Coleman's personal information, does need to be redacted. Other than that, though, Judge, I would request that you enter on the record the exhibits that were attached to my notice of defense.
We can't do that, Your Honor. The entire exhibit has to be stricken, and then she would have to file conforming documents. You cannot take one page out of the document because it's the entire file within the court record. It's electronically filed. There's no manner to remove one page of her document from the electronic record.
I have them here, Judge. I'm happy to present one at a time on the court's time.
And again, Your Honor, then she would be in violation of Supreme Court order, which requires her as an attorney to file all documents in a forcible detainer action electronically.
They're all filed except for the one page I'm asking the court to redact.
But that has to be stricken by rule. There's no discretion.
I have no
in it.
objection to the court striking it.
The entire document has to be stricken.
Okay,
Mr.
hold on really quickly. This is the first time this court has heard this argument before. What is the rule that states that the whole document has to be stricken and that the court cannot redact the personal identifier
It's
information?
CR 703 sub 7. This is a non-conforming document, so therefore it has to be stricken. Because it's one document electronically filed, the court doesn't have any way to retract one page electronically. The court's only ability to do such would be to retract the entire document, because that's just the way our CourtNet system works. And then Ms. Cotton, in order to get the record in, by rule, has to file a conforming document, which has to be by Supreme Court rule done electronically.
Judge, if you could have Mr. Ben read that rule.
Do you have it handy?
He's claiming what
where you
it
can
says,
read?
but he hasn't.
I don't have it in front of me. I can turn my computer back on.
I would ask you to take judicial notice of it. Furthermore, I
I
believe
can't take judicial notice of it. I'm not familiar. I've never
all right.
heard it before, so. I would
if
need
Ms.
you to
Cotton
read
would
it.
actually have bothered to have read our response, the relevant portions of the rule are quoted verbatim in our response.
All right, she wants you to read it into the record. Do you have a copy of your response so you can read it for the court, please? I will give you time to do that. I'm sorry that let me turn my computer on. But to expedite
All right,
things.
so
if
we're
you
going to
have-
start with CR 703 sub 1, unless the court orders otherwise in a civil filing with the court, excluding domestic violence matters that contain certain personal data, including individual social security number or taxpayer identification number or birth date or financial account number, and an attorney or party making the filing must redact the document so the following information cannot be read, all but the last four digits of the social security number or taxpayer identification number, B, the month and date of the individual's birth, and C, digits of financial account. Then we go on down to 703.7. An attorney or party failing to comply with this rule will be subject to the sanction powers of the court, including having the relevant filing stricken from the record. A conforming copy of the filing previously stricken from the record for a failure to comply with this rule may be refiled unless otherwise ordered by the court.
Ms. Cotton, may you refile that with the proper
Absolutely, Judge.
information redacted? And is that going to have any bearing on the motion to void and seal that's going before the court today or anything else that's being heard? We obviously don't want to put Ms. Coleman's information out in the street, so to speak. That's slang, but we certainly want that removed, and I give you permission to refile with it. I don't think it has any legal basis on what you're trying to achieve today. Is that
Judge,
correct?
I agree with Mr. Benz that should not have been filed, the social security number or the date of birth. I do not agree that it requires the court to redact the entire filing. And I'm happy to white that out and refile all of the exhibits the same as I did with my notice of defense.
And would you state on the record that your only thing that you're going to be redacting is that information that was just spoken of?
Yes, Judge,
Which was her personal identifiers.
just the social security number and the date of birth. As this is the signature of my client on the lease, I will leave her name and the date that it was signed.
Okay, very good. So that's satisfactory for the court. Thank you, Mr. Benz, for that. For reading that to the court. As you said, it is in your filing. First time this matter has come before the court, and we all know that accidents happen. I'm certain that that was not meant to come to me, and I will not look at her social and her personal identifiers, but I think we can move on knowing that Ms. Cotton is going to file a redacted portion, and that's all she is redacting are the personal identifiers. So I'm giving her permission to do that. All right, what's the next matter before the court?
Thank you, Judge. So in order for the court to, even if you take it under submission or rule today, we would be requesting that the exhibits to the notice of defenses that I'm going to refile absent those two items on the end of the lease be admitted on the record.
Any objection?
Yes, we will object to all of them. She's not laid any foundation or verification of any of it.
All right, if you would lay some foundation, please.
Mhm.
And do you have a copy where you could, if you wanna, I know it has to be done electronically, but let's just keep going. I was gonna
Okay.
say I have a Sharpie, but let's just keep going.
Judge, the first exhibit is the 7-day notice, which was provided by Mr. Ron, the Ron Law Firm.
Okay,
Your Honor, we want to go on the record of objecting to this particular item because Ms. Cotton obtained it through subterfuge. Ms. Cotton, knowing very well that she is not permitted to contact our firm for any documents due to prior instances of her behavior, used a third-party intermediary to seek this out on her behalf without disclosing they were seeking it on her behalf. Therefore, we believe that behavior is highly unethical.
would you like to?
Judge.
Would you like to, I need quiet in the courtroom. And if anybody, it's gonna be a while, so I mean, if y'all need to get up and walk or get fresh air, if, feel free, okay? But this is gonna be a while, okay? All right, Ms. Cotton, would you like to respond?
Yes, Judge. I'm a little upset that Mr. Benz would accuse me of subterfuge in front of the court. And in response to that accusation, I have brought the email thread of our request that was made by volunteer Marilyn Nash, who was the only person working on this case at that time. You know, Mr. Benz knows that I am the senior attorney for the Volunteer Eviction Defense Program. We have paralegals and attorneys who volunteer their time pro bono for defense cases. Ms. Nash had taken this case up and was working the case up to see if there were defenses. She is the one who sent the email request. She was very clear that she was working with the volunteer program when she asked Mr. Benz for the document, and he provided it to her.
Our response is very clear, Your Honor. For the last 5 years, Ms. Cotton's always requested those documents herself on cases that she's been involved in. Ms. Cotton didn't on this request is because she's very much aware due to her prior nonsensical motions for sanctions and her discussions with Ms. Ron. Ms. Cotton is prohibited from contacting our office for any documents because we will not provide anything to Ms. Cotton only. Rest of legal aid's fine, but just not Ms. Cotton due to her instances of poor behavior toward our firm. Having this third party reach out to us, who then disclosed to us that she was seeking the information on behalf of Ms. Cotton and Ms. Butler, Ms. Cotton's associate, after we asked who it was being sought for.
Would you share the document with Mr. Benz and then?
I'm
Mr.
aware of
Benz,
the email
Okay, may I
conversation.
see the document?
And we
please?
object to it. It has no relevance.
Okay. I'm curious. It's been spoken on and I'd like to see it. I'm not gonna enter it as evidence. I just want to see.
Judge, if you start on the bottom of the thread, which is on the second page,
All right.
Ms. Nash says, Mr. Benz, I'm working as a volunteer for the Legal Aid Society and reaching out regarding the attached action. Ms. Coleman does not have the notice mentioned in the complaint. Please provide a copy of the notice along with the manner of service at your earliest convenience. It's my understanding Mr. Benz provided that, and then he responded, please advise as to whom the attorney on this matter is. He had already given the documents to Ms. Nash, as we do not show an entry of appearance having been filed as is required by the court. I'm attaching the notice. If your client did not receive the notice, it's because she did not sign for it as it was sent certified mail. Thank you for the documents. I assist with the workup of cases for the Legal Aid Voluntary Eviction Defense Program, and if cases are not placed with the pro bono volunteer, Rebecca Cotton or McKinley Butler represent the clients.
Signed, Marilyn Nash.
As you can see, Judge, Mr. Benz provided those documents without asking. I also think the court should take great pause in Mr. Benz's admission to this court that he refuses to provide any information to me.
And Your Honor, you cannot make me provide her information. I'll be glad to appeal that all the way up. This woman has filed more ridiculous, wasted time sanction motions against my firm to the point that if she does it again, we're filing a bar complaint. It's because of her behavior.
Hold on, what am I hearing?
It's because of her behavior, her rudeness, and her unprofessionalism toward me, Michelle Ron, and Emma Blackmer and our firm that Miss Cotton and Miss Cotton only at Legal Aid is not allowed to get information from us. The rest of Legal Aid shows us courtesy. They will email us. They will raise their defenses. They will call us and discuss matters. Who doesn't? Rebecca Cotton. She
Not
simply
relevant,
files
Judge.
these,
Objection.
she
Mr.
simply
Benz.
files these ridiculous sanction motions, which in herself, in her own language, she admits is in pure retaliation
I
in
did not,
violation.
Judge.
Mr.
I object to
Benz.
that.
She
When did she
does.
say
She
that in her
says
own-
that she
Mr.
filed
Benz.
this sanction motion solely because you required her to file her briefs
When
before the
did she
hearing.
state
I
that
did
it was
not,
in
Judge.
retaliation?
When she says in her notice of filing that she is solely filing the request for sanctions because you ordered her to file her defenses
She said this on the record or in
in
writing?
writing.
Where, point me
Judge,
to that.
In her
Mr.
notice
Benz
of
is jumping
defenses.
ahead, and I'm
Okay.
prepared to address his
And when she
accusation.
did that,
Sir,
that
Mr.
means it's
Benz.
retaliation.
Okay, first of all, I find there, going back to this, the email chain, I find there is no evidence of bad faith here. And so the conversation about, subterfuge and all of that, I'm not going to address that any further. This is not evidence, but I will keep it up here, okay? All right, what is the next issue?
Judge, if you would, ask Mr. Benz not to refer to me as woman, but as Attorney Cotton.
Mr. Benz, and I want both of you all, and Mr. Benz, I don't like the adverbs, adjectives, things that you
And I
are
will
using.
refer to her as a
There-
woman.
Her name is Miss Cotton, right? Ms. or Mrs., I think it's Ms. And so we're going to show respect to both, all the parties in
We
the
will show
room.
them the respect that
You
she
don't cut
feels.
me off. That
Yes, ma'am.
includes me. I'm the biggie. I'm the judge. So you're gonna show respect to me, to opposing counsel, and to this court,
We will be
okay?
glad to show you
And-
and Ms. Cotton the respect that Ms. Cotton never shows my office.
Mr. Vance, that was not necessary. Please, I don't want to get into threatening contempt and using my gavel. We need to proceed. As you see, there are about 25 people in here. Let's just continue on. Thank you. All right, what's the next
We're
matter?
at the point of requesting the court admit the 7-day notice on the record.
All right, and that is attached
We object.
to,
There's no foundation been laid for it yet.
all right, so let's go back.
She would need to bring the paralegal in that required it to testify how she obtained it and why she obtained it. Ms. Cotton can't testify to that via emails.
Judge, Mr. Benz provided this notice to us.
Still objection, Ms. Cotton's not laid a foundation to put it into the record. The
His
rules of
client's not
evidence,
here. I can ask my client, but
the
I
rules
think
of
she's
evidence
been through
apply.
enough.
Well, she asked her client, it would be interesting how they got it because in Ms. Cotton's own emails, it states her client never saw the letter.
Mr. Benz has a duty to be forthright with this court. He knows this to be the notice that he provided to us, and he's just being argumentative.
Let me look at
Your
back. at
Honor,
the-
when you do-
Can you let me pause, please?
Yes, ma'am.
Okay. Is there evidence of an attachment on these emails? Are you saying this acknowledges that he sent it, or is it attached to this, or where do we have where you can show that Mr. Benz is the one that actually sent it?
He says in his response, I'm attaching the notice.
Okay, please advise as to whom the attorney on this matter is. We do not show any entry of appearance. I know you've read this once already. Having been filed as is required by the court, I am attaching the notice. If your client did not receive the notice because she did not sign for as it was sent by certified mail as required by KRS 383-560. So, Mr. Benz,
I will stand by-
is this your signature on this email stating that you did attach it? I don't see an attachment here,
But
but
there's no proof that the letter she's trying to submit is the attachment. She needs to lay a proper foundation, which she's failed to do.
would you give me as much as you can and I'll determine whether I can accept it or not? The foundation, is that basically going to be the foundation that this is indeed the letter that you received? Or
It is,
that Ms.
Judge.
Nash received?
Yes, Judge, this is what we received from the Ron Law Firm. And it's also dated, the date on the front of the complaint, October 31st. And it is addressed to my client at 1930 Olive Street. The amount that's alleged due at the rent balance is also the amount alleged on the complaint.
And Mr. Benz, that is not satisfactory for you?
I don't believe she's laid a proper foundation of the authenticity.
All right, may I
of where it
see the
came
letter,
from.
please? And I'm
Yes,
gonna
I'll go
match.
ahead and stipulate to it, Your Honor, and move on.
All right, so stipulated in our, is this gonna be evidence?
Yes, Judge, we're asking it to be admitted on the record.
All right,
At that point, we had to object because she didn't lay the foundation.
okay. I am,
I'm happy to
over his
present.
objection, I'm gonna accept it and mark it. Have we already had exhibit one? I think that was the last hearing. Is this the first exhibit today?
We also object,
It is,
Your Honor, on the
Judge.
grounds of relevance because we don't see how it's relevant to her
I don't
motion,
know yet.
for her motion for sanctions.
Okay, I don't know either. So I think your objection is preliminary. I don't know how she's gonna use this letter. Do I have the letter?
Judge,
Thank you, Deputy.
I would like to have a copy for my continued
Oh,
argument.
yes, ma'am. Would you mind, Ms. Jan? Do you need a copy as well, Mr.
Have
Benz?
it.
And
Okay,
Judge, before we continue, it's very clear that Mr. Benz intends to object to every single exhibit that I'm going to provide the court on the basis of foundation, even though they were provided by his office.
yes, ma'am.
I filed my notice of defenses. The court, Mr. Benz requested that we file in writing. The court ordered us to file in writing. We filed in writing. Mr. Benz had an opportunity to respond. His only response was to dismiss this case by filing a voluntary dismissal. So he had an opportunity to object and to do all this in writing to what I filed. He did not. If he had different documents to produce to the court in order to make his argument for a forcible detainer, he would have been required to file those on the record. He did not. He just dismissed the case. Now he's here. He wants to argue without his client present, even though his
Objection,
client
our clients not need to be present.
not
And
finished.
I'm allowed to cut you off and
Not
object, Ms. Cotton.
finished.
Our client does not require them to be present for this frivolous motion for sanctions.
Okay, he has objected. Please continue.
Judge, a CR 11
Objection noted.
motion. Specifically, the judge can order, if the court finds that there is a violation of CR 11 and that the document filed with the court was signed in violation of the rule, the court, upon motion or upon its own initiative, shall impose upon the person who signed it, a represented party, or both, an appropriate sanction. His client today is subject to the court's potential sanctions, but they are not here.
And they're not required to be here. Had Ms. Cotton wanted them, she should have exercised her subpoena power to have them here. She failed to do so. Therefore, she cannot object to them being absent today.
The case was not dismissed, Judge.
All right, let's move on. We know.
Again, Your Honor, she had the opportunity to subpoena them. She
Okay,
chose
they're
not
not
to do
here.
so.
All right, they're not here.
That's on her, not us.
All right, let's move on.
Judge, the second filing that I make is actually part of the court's record in case number 25C010309.
Objection irrelevant.
Judge,
And
this,
again, I can't rule on your objection because I
A
don't know,
previous eviction filing is irrelevant to this matter.
and I don't know that to be true because I
And
don't
if
know
she's
where
going
she's
to
headed
introduce
with
this
it.
one, I want her to introduce the other 24 against this tenant.
All right,
I'm
let's
happy
see
for
where.
Mr. Benz to introduce whatever he likes, but this is the one I'm introducing.
Okay, objection is noted. I don't know where she's headed. What,
Judge,
okay,
there
this
was
is
a forcible detainer complaint that was filed prior to the one that the court is hearing the motion for sanctions on today.
okay,
And there was a judgment entered on October 27th of 2025. And there was a warrant for possession entered on the 28th. In that case, neither the judgment nor the warrant were dismissed in any way when the plaintiff in this case filed the present action. No, not filed, sent the notice that the court just admitted on the record. The October 31st notice was sent, and it was only from the 28th, 29th, 30th, 31, 3 days from the warrant being issued that they noticed her on a following eviction.
okay. I'm
What
gonna
I'm
have
not
to,
hearing
wait,
and I object to, Your Honor, is this whole
wait,
set of documents is what Ms. Cotton is not telling you is that the tenant made a partial payment of the balance she owed after the filing of the judgment or entry of the judgment into forcible detainer.
Is this an
Therefore,
objection,
I said I was
or is he
objecting.
testifying?
sir, watch your tone. I said we're gonna remain respectful. We're gonna remain respectful. I really was gonna ask Ms. Cotton because I got a little lost in the sauce, so to speak. So I believe you said there was a judgment granted
Yes, Judge.
And did you say that that the landlord did go ahead and get the eviction warrant, but then it was never active? That's where I kind of got lost.
Yes,
Can you
Judge.
take me through the timeline
3
again?
days after the warrant was entered on October 28th, they gave the notice letter to my client
This notice letter.
for this case.
Okay.
However, this judgment and warrant was never set aside.
Objection, Your Honor.
And it
So
goes
it's still
to-
floating out there.
Objection, there is
Yes.
no legal requirement for the landlord to set aside that judgment and warrant.
I'm merely asking that the court put this on the record so that I can refer to it in my arguments.
All right.
We object.
It's
One.
already a
Objection
court-
noted. I'm gonna,
Excuse me, Ms. Cotton, I
need
get to
stop.
state my objection in full
Oh,
before
I
you
thought you
interrupt
did.
me.
Objection noted.
There is no legal requirement to set aside the judgment or the warrant. The landlord took a payment after the fact, which would nullify said documents from the landlord being able to act upon them. It would then have been punitive on the tenant to
Judge,
ask for
Mr.
the
Benz
set
is
aside.
testifying.
I'm
I
arguing, Ms.
object.
Cotton, if you would please quit interrupting
He's-
me without filing an objection or
He's
noting an
telling the
objection.
court, I'm objecting to him testifying. He's telling the court that his client accepted a payment. He doesn't have anyone here to testify to that.
Mr.
She's been testifying all afternoon, Your Honor.
And you've objected every time, and you've asked that she have to lay foundation and tell where she's
She's
getting.
already laid the foundation when she put the notice letter in, because it clearly shows the
All right,
payment.
so you want the court to know the reason why is because they accepted a payment.
Yes, ma'am.
Okay, that's satisfactory. I do want to see it because I think we're headed somewhere, and with all the objections, I can't find out where we're headed. So this, over your objection, this will be plaintiff's exhibit number 2.
And
Okay.
Judge, the court should have all these exhibits in its
Right, but
filing.
right now, since we're just rolling,
But I
yes.
just wanted to.
It makes more sense for me to hear it as it comes. So actually, I signed this immediate possession and was signed on 10/27/25. And then the next step after that comes the eviction notice warrant for possession, which I signed on 10/28. And so again, it is your testimony that, what was the next date? I'm trying to keep all this together. I'm gonna have to make
The
notes.
notice given to Ms. Coleman in the present case was on October 31st, 3 days
October 31st,
after
3
the
days
warrant
later.
of possession
Okay.
was issued.
All right, so I'm gonna try to keep this timeline together. Okay, where are we headed next?
The lease agreement, Judge, and I will need Ms. Coleman to be sworn in so she can tell the court this is their lease.
All right, very good. Ma'am, if you will please raise your right hand. Do you swear or affirm that the testimony that you're about to?
This is a mess. Okay. Can I-
Ma'am,
Huh?
okay, she
I'm
needs
sorry.
tissues.
Yeah.
Do you need to breathe?
Yeah.
Okay, let's take a recess,
Thank you,
okay?
Judge.
Let's take a 5-minute recess. The court needs one as well. Oh, we were going to swear your client. Ma'am, are you ready?
Yes, ma'am.
All right. Do you swear or affirm that the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. So you're going to answer the questions from your attorney, Ms. Cotton, and then, of course, Mr. Benz will get to cross-examine you on anything that you testify about if he
Okay.
chooses to do that,
If my
okay?
understanding, she's just testifying to the lease. We'll stipulate to the lease is the correct copy, Your Honor.
All right. Was that the only reason you needed her
Yes,
to
Your Honor.
testify?
Yes, Your Honor.
All right, so you all have exchanged the lease and it is the correct copy of the lease, and this is going to be entered as an exhibit?
Yes, Judge.
All right, any objection?
Except for the redacted information, Judge, that the final page is the page that has the social security and date of birth, which will be redacted in my filing.
All right.
Just
And
our standing objection on
your standing
relevancy.
objection is so noted. If you like, until I get your copy, do you want me to use my Sharpie to redact
Yes.
it, or have you already redacted? Do you want to redact it here until I get the electric so that Deputy, would you mind handing Ms. Cotton a
I
Sharpie
appreciate
so she
that.
can
Thank
redact the unofficial copy? We'll call it the unofficial copy.
And Judge, would you like me to present it to the court like we have the other documents?
Yes, please.
Okay.
Are you needing it to testify further? You can wait till the end. I've got the sticky label ready, but if you
Okay.
want to wait till the end,
Thank you.
if you're gonna ready to use it, okay. I'll make a 3 on here that's gonna be number 3. Thank you, Deputy, for my Sharpie back. All right, well, let's proceed. So we have entered the lease as exhibit 3. What are we proceeding with next?
Judge, I don't believe that there's any disagreement between myself or Mr. Benz that Snack Pack 3 Family Trust is the owner of the property.
We still don't understand the relevancy of her argument, Your Honor.
All right, so that I'm sure is forthcoming. Is there any objection? Here's what I see, SNPACK03 Family Trust. And so you said that they are the true owner. Is that what you stated?
Yes, and I can present the PBA and the deed, but
Will you
Mr.
stipulate to that, Mr.
It's
Benz?
the correct PVA report in the deed. We still object to relevancy as it's still relevant.
All right, objection notice, if you would mind reserving that until I find out where we're headed.
and Judge, I'm going to ask Ms. Coleman concerning the ledger that was attached to my earlier filing, the notice of defenses, which Mr. Ben's got a copy of.
This is the ledger.
Yes, and I'm just going to ask her if this is the ledger she provided to me.
Yes. Yes.
And Judge, do you want me to hang on to that too? And then
Again,
hand
if
it
you're
up?
gonna be using it, I see the information as you stated is in the packet, but I do like to put my little, so this is gonna be exhibit 4, is that your motion?
Yes.
And any objection? And again, I know you've reserved an objection because you say you don't know relevancy at
it's
this
relevant-
point,
it's
so
irrelevant, but-
you may get to the end and review that again for me, but right now I don't know where
Just
we're
for
headed.
magic math notes, Your Honor, we're going by the numbers you have on the exhibits versus the letters on all the ones Ms. Cotton filed. Because she's calling them A, B, C, D, E.
Yes, we're gonna, in my file, ultimately for appellate
Okay.
purposes, we're gonna do the ones I've marked with
I'll
my.
just translate letters to numbers and,
Okay, we'll just name the name of the document.
yeah.
Okay.
All right. Ms. Colvin, is this the tenant statement that you received for August 18th, 25 to November 18th, 25?
Yes.
And did you provide that to me?
Yes.
And we're requesting that be admitted, Judge.
And say, will you tell me the name of that document again?
It is tenant
Tenant-
statement, August 18th to November 18th.
Mr. Benz, of course, you've seen this, and any objections to that being entered?
That's gonna be our standing objection.
Standing
on
objection of relevancy, all right,
And then Ms.
and
Coleman,
overruled at this time.
the final tenant statement from 4/21/24 through 4/21/25. Is this your tenant statement?
Yes.
Okay. And did you provide this to me?
Yes.
All right, so that will be ultimately, the last one was, plaintiff's exhibit 5, the next will be 6, standing objection,
Yes. ma'am.
relevancy, so noted.
So Judge, it's my understanding you did have an opportunity to read my notice of defenses.
No, I received it, but no, I do need you to make your oral argument.
Okay, so, the notice of defenses was filed prior to the dismissal of the case at the court's order. And each of the documents that I've asked the court to put into the record were referenced in these notice of defenses.
Yes,
They
ma'am.
were considered by myself and they were a part of my defense. Mr. Benz, the next day after receiving this notice of defenses, filed his voluntary dismissal in this case. The court can infer whatever it infers from that.
Objection.
And
State, wait a minute, hold on, objection has been made,
She's wanting to put words into people's mouths and it can question our motives. If she wants to ask, why was the dismissal filed, let her ask me versus asking you to make inferences, which I believe she was trying to allude to that we had ulterior underhanded motives. Then waiting till after she filed her defenses till dismiss. Forget the fact that we were unaware of any of her defenses until she filed them.
okay.
Judge, I didn't-
The court's not gonna infer anything, okay? I'm going to take it on its face that you filed a notice of defenses, as you mentioned, that I asked you to do so on the court record, and you filed it, and then you stated that thereafter, there was a voluntary dismissal.
the way this hearing is going, Judge, it seems like you're going to be making your ruling today
I doubt it.
because I'm comfortable to rest on my notice of defenses and the arguments made concerning the exhibits that I've presented to the court. if the court is going to be taking it, we can save the court some time and just refer to my arguments within my filing.
Would you allow me to do that, review your, in light of the fact that we have so many hearings and that I have
Requesting
not
the
been
court
able
do
to?
that.
Yes, okay,
I think we
and,
need to have the oral arguments on why she thinks she should get $6,000 in sanctions.
That's separate, Judge,
right,
from
we
my
haven't even
CR 11
gotten, we haven't
motion.
even gotten into that.
It's all part of this. This is her argument for sanctions, Your Honor, and then
All right.
that's her monetary amount. I think we have to hear why she should even get sanctions before we get to the monetary amount. The notice of defenses, in my opinion, has to be stricken because she says right in the beginning of it, she's requesting that we pay attorney fees to legal aid in representing Ms. Coleman specifically because of the spirited demand that we be required to file our defenses prior to the hearing. That's retaliation because we asked her to do her job and do something other than state buzzwords in demanding a hearing, and she demanded sanctions. That is nonsense.
Judge,
Okay,
response?
yes,
Retaliation is not a defense to a CR 11 motion, Judge. It's Mr. Benz's, he's theorized that that is the case. The only defense is to say that you did a reasonable inquiry before you filed your pleading. And I'm arguing that there was not a reasonable inquiry before the filing of this complaint.
And if she would actually have read our response, she would notice that we did do a reasonable inquiry. We went in quite depth on how it was done. But what she fails to mention, Your Honor, is by making this pleading, she violated CR 11 herself because she says it's retaliatory. And when you state that I'm speaking, please.
He's putting words in my mouth.
all right, Mr.
When you
Wait a
state
minute, wait a
you're
minute. Okay,
taking
is
an
somebody,
action.
is somebody ill? Is somebody okay? Ma'am, are you okay?
Yes.
Okay, because I couldn't hear. So do you need to get some water? No, I'm concerned about you, but if do you need water or anything? Okay, wait a minute. I really couldn't hear. So
All right, when you
wait
state.
a minute. Hold on. Hold. I need to redirect for a minute. Okay. So you pointed this out earlier and you made this allegation earlier, Mr. I don't know what I was going to say, Mr. Benz. And so what I'm hearing from you and what I kept looking for was the language. I mean, obviously she's not going to put on in her filing that she's retaliating. So you're also asking me to infer,
I'm
right?
basically not asking for an inference. She states it. She demanded.
Give me the exact language. I want to
We
highlight the
demanded she be
language.
sanctioned because you required her to file her defenses with the court.
Okay,
She's demanding we be punished because she had to take an
where
action.
is the language?
The plaintiff objects to, I'm sorry, wrong document. And Ms. Cotton, it's here, it goes. Defendant will also request that the court order the plaintiff to reimburse Ms. Coleman for the unlawfully charged legal fees and order plaintiff to pay attorney fees to legal aid for its time in representing Ms. Coleman, specifically because of its spirited demand that be requested to file our defenses prior to hearing and to void and seal this action pursuant to 703(4)(b).
He's reading from his response, Judge.
I'm reading an exact quote
I'm just
from her
looking
notice of
for-
defense.
Okay,
I'm
could
just
you
looking
please?
for it.
I'm looking for it too. Can we, there are page numbers, there are paragraphs. I'm desperately seeking it, Mr. Benz. I need a page number and a paragraph, please.
It's the second page, the first paragraph. Defendant will also request that the court order plaintiff to reimburse.
Wait a minute,
et cetera, et
second
cetera,
page, I'm, my second page.
of Ms. Cotton's notice of defenses.
Okay, the first paragraph or the one,
I'm sorry,
one
it starts
point
there-
LREI.
It starts at Schenkel versus Turner.
Okay, you're
And
up
it's
there
about
at the
halfway
very,
through it
okay,
where it goes, she starts going, defendant will request.
okay, I'm gonna start highlighting there. Would you please read?
Defendant will request that the court order plaintiff to reimburse Ms. Coleman for the unlawfully charged legal fees and order the plaintiff to pay attorney fees to legal aid for its time in representing Ms. Coleman, specifically because of the spirited demand that we were required to file our defenses prior to the hearing and to void and seal the actions pursuant to 703(4)(b). As grounds in support, defendant states the following.
So it's that paragraph and then anything following is the reason for she's asking.
Well,
That's the way I read
she
that.
goes forth to thinly disguise her retaliation by making some
Objection, Judge.
arguments.
My document speaks for itself.
All right,
And my opinion of her document is she is seeking sanctions. She's asking this court to be an arbiter of personality disputes instead of a court of law. This demand for sanctions is solely because Ms. Cotton could have any time prior to having to spend time in her filings, called us, told us of any of her defenses, raised any
Objection,
of them.
Judge.
I'm speaking and I get to finish, please.
Well, okay, so you're never gonna object.
No, she
in
keeps
the
telling me
middle-
I can
Wait a
interrupt her,
minute.
so it's good for
Okay, so
her.
you're not gonna object anymore when she's talking because it has to go both ways.
Fine, let her object, but
Okay,
she's gonna no
objection.
longer interrupt me.
Your
Mr. Benz
objection.
is spewing his opinion about what I wrote. And it's not relevant what his opinion is or how he feels. It's what I wrote that matters.
All right, so he has put forth that he believes this is retaliatory. I will read.
And if we want to
And
go
I
into
will-
what she wrote, then we're gonna have to get into the fact that she has several factual misstatements of what she wrote, where she, without any support or reason, calls things unlawful legal fees when they are in fact lawful, and that she has other complete misstatements of fact that read to the reliability of her entire argument.
Is that in your response, sir?
Yes.
Okay, I will look forward to reading your response. As I mentioned, I kind of get things last minute, and so I have not had the opportunity to review, and that's why we're trying to close the oral argument so
We
that I
still
can
not
take
heard
all of this
anything.
under submission.
Yeah, we've still not heard anything from Ms. Cotton. She's saying CR 11 says we had to act and didn't do a reasonable review, or
Well, she did mention that she did not
But
get
we've
to
not
finish.
heard-
Wait a minute. I don't know that she's gotten so what I have before me is a motion to void and seal and a motion for sanctions, and I'm not certain that Ms. Cotton has been able to finish. Ms. Cotton, and you can make your objections, but I would like to be able to get her to be able to argue her motions so that we can.
well, I thought she rested all
I
of it and
don't-
said just read her brief.
You mentioned something about you had concluded and read your brief, but I would like you to touch upon, have I heard everything that you're with regard to your motion to void and seal as far as what you want me to pinpoint?
No, Judge.
Okay. I want to give you that time to do that, but
I was on my first step, which was to ask the court to admit the exhibits on the record.
all right,
and
and that
it's
has been
taken-
done.
Yeah, that's
Okay.
finally done. Mr. Benz keeps referring to the line in my notice of defenses, but I will tell the court, he never filed a response to the notice of defenses. He filed a motion to
Objection.
voluntarily dismiss.
Objection, Your Honor.
He has
Your
filed,
Honor, I get to object it stated. She
Objection.
doesn't get to keep. We didn't have to file a response to her notice of defenses. When we read them, we saw that she had a point which she had never raised prior, so we voluntarily dismissed. That in itself should have been considered a response to the motion to dismiss or the notice of defenses, as we were notifying. We agree you had at least one valid point and we're dismissing. If she would want me to respond to her entire document, we would be more than happy to take it apart piecemeal.
Ms. Cotton, would you agree that that could be a response to a motion of defenses for plaintiff's counsel to say, she's right. We didn't do this
I'm saying he
correctly.
did do that, Judge. He filed a motion to voluntarily dismiss.
Okay, so would you agree that that was a response?
Yes.
Okay,
Now he's arguing that what I wrote in there, that the court should consider it retaliation.
okay.
No, I'm arguing that you stated that you were acting in a retaliatory manner when you stated that your sole basis for seeking sanctions is because you were required to do your job.
And this is
I didn't say so.
about the third time that I've heard that, and I think
We're
I
going to
have,
keep hearing it because it's the facts.
well, I believe that I have highlighted the portion that you want me to look at, and I see that one line, but then I also see 3 or 4 paragraphs after that when she explains while she's filing this motion. And then you mentioned that it's couched and that she's trying to support. And I just don't need all of that. I want to read her motion. I want to read your response to defendant's motion to seal and for sanctions. That's why we're here today. And, the name, I don't want to say name calling. There haven't been any names called, but there have been disparaging remarks. There have been things that just really aren't appropriate and aren't needed for me to make my decision. So I would like to get through this. I'm sure everybody else in this courtroom would like us to get through this. So the motion to void and seal, we know that sometimes this is asked for, sometimes it is not. Can I just ask you to briefly tell me why Ms. Coleman should be entitled to have this voided and sealed, please?
Because they never had the legal right to file in the first place because the notice was improper and they had
Okay.
waived their right to proceed on those defenses.
Would you,
There is no legal mechanism under Kentucky law to void and seal a forcible detainer action once it's filed. Ms. Cotton tries to cite Rule 703, I believe it's sub 4, but that only gives the court the right to seal certain aspects of the case, or maybe perhaps even the whole case, not to void the case. To prove that there's no mechanism to void a case, to make it didn't exist under Kentucky law, this is the fourth straight year the General Assembly has taken bills up to consider such and yet to pass such. If there was a mechanism to void a forcible detainer action after it's been filed, the General Assembly would not be needing to take such actions to create the mechanism. Ms. Cotton only cites the rule about sealing for privacy reasons, nothing about voiding.
all right, pause there.
Furthermore,
Wait a minute, pause there. That was a good stopping point. Do you have anything for the court about voiding? Mr. Benz has acknowledged that the court can seal. Do you have anything, case law, or have you cited something that gives me the authority to both void and seal this dismissal?
Judge, we would just defer the court's interpretation of 704,
Okay, so if
703, sorry.
I know
Section
that there
4.
have been prior void and seal orders that have been granted, and I'm not sure whether they got voided and sealed, but I know that they have been granted. If she changes to just seal, would you be objecting to sealing? Or do I still
I
need
don't
to
think-
make a judgment on it? Because we know, unfortunately, I'm just gonna say this, and
it's a tough
we know
decision.
that people are trying to get,
think-
there are lawyers and people in the Senate and Congress, in the state government that are working on expunging dismissals for forcible detainers, just like you can expunge a
Yeah.
criminal action,
And
and that has not come forth. And so it is unfortunate
my
that,
contacts, they think this is the year that will pass.
okay, well, great. So until that passes, I understand the
I think
need
I
for
would let you
someone to
seal
be
it.
able to seal.
I think I would let you seal it. That's completely your
Okay,
your
okay.
discretion.
So
There is
I'm
no
gonna grant that
mechanism to
now.
void.
If there's no, I will research it, if there's a way to void it. But Mr. Benz is saying it's not, and you said depending on my discretion on how I read that statute. But I will absolutely seal your conviction. It's not a conviction. I'm sorry. I've come from
Fine.
criminal court. I will seal your dismissal, okay?
And
Now,
just for the record, Your Honor, I would note that we have never agreed to void one because there is no mechanism.
And
under
you
law. And
shared that, I
Judge
got it.
Leeson and Judge Buckner both would have to begrudgingly agree with me on that argument when I've made it before, because there is no mechanism.
Okay, and if there's not a mechanism, I can't make it happen. And I'm glad to hear that there are going to be expungements in the future. All right, so the last thing we need to discuss, and again, just highlight about the sanctions.
Okay, thank you,
Okay.
Judge. It is imperative, and this is just oral argument, Judge. This is
Yes,
not
just
argument.
oral argument.
It is imperative that this court be able to rely on the complaints filed by plaintiff. Out of 15,000 forcible detainers each year, only 1,053 receive representation from defense counsel.
Objection irrelevant.
That is 7%.
Objection irrelevant.
Objection noted.
This court might agree that standing, improper notice, and waiver are the three most common defenses presented daily
Objection
in
irrelevant.
this
Objection
courtroom
noted.
by legal aid. This complaint arguably violated all three.
Objection. Facts
Standing,
not in evidence
Objection
and
noted.
irrelevant.
the court has admitted the lease.
I will agree that you said that there are three. Are you getting ready to break down for
Yes.
me? Okay, she's gonna break it down. Go ahead.
Standing, this lease is between GNCS, and if you read the complaint,
Objection. She's not introduced any facts about GNS, or she's failing to acknowledge that a successor in interest can be the owner.
And I'm
Judge,
sorry, I'm lost
court's
too. I
holding the
remember
lease.
something about snack pack. Now I'm learning
oh,
something.
you don't have it because I'm holding it, so I can hand it to you, Judge.
Okay,
And she's failing to acknowledge what a successor in interest is.
Mr. Benz
I
had
don't
every
think we're there
opportunity
yet.
to
I've
write
noted your
that.
objection. I've noted your objection, and she's gonna show me how GNS, I believe she said, is
She's already introduced that. She's already said that they're the owner of record.
okay. And what is this that I'm receiving? What is this?
That is the lease that I asked to be admitted on the record.
All
If you
right.
read it, it says GNCS this lease is between GNCS and Nikita Coleman. On the complaint that was filed in this case, it says, comes the plaintiff and for his complaint states that on the 30th day of September 2024, defendants contracted to lease 1930 Olive Street, Louisville, Kentucky, under a written lease with plaintiff as lessor. That's my argument, that there was an issue with standing right off the bat.
We object to that, Your Honor. There is no issue with standing.
Will you share with me
He's
why?
I get to
testifying.
finish
Hold on.
my
Objection.
argument. You're testifying, Ms. Cotton, so
Hold
I
on,
get to respond as well.
Stop. Would somebody want to explain to me?
I would be glad to if she would not interrupt me.
Okay, but she's stating that that's testifying. Ms. Cotton, somebody needs to explain to me. I don't know how I make a ruling if I don't know the connection between GNCS and LREI. And who is the other company listed? And I know there are subs and subs. SNPACK03 Family Trust.
And Judge, since this was my motion and standing is one of the reasons that I'm asking for sanctions, I will tell the court that I filed the lease and I filed that full argument with the court.
Okay, so
Mr.
something
Benz
I
had
need
an
to.
opportunity to respond.
Again, Your Honor, we've
If
already
it
been
wasn't-
over
You can
that
note your objection.
objection.
You can note
We
it.
did a
I need
response
to
with the dismissal.
understand.
She can't keep harping that we didn't take apart her entire argument. If
All
we're
right,
going to
thank
do
you,
that,
but I now want to understand. I'm asking her to argue this orally so that it'll make sense to me
I
when I'm
understand that she
reading
keeps
it.
demanding that we didn't file a response.
Okay,
We
all
want the right to take her apart, whole argument apart piecemeal in writing, since that's what she keeps demanding.
I'm just reading what's on the documents.
All right, could you share with me how these, if they are interrelated or if you believe they are
I
not
don't know, that
interrelated?
would have been Mr. Benz's case in chief. He would have had to have presented evidence on that for the court to hear. And since we didn't have a trial and we had a voluntary dismissal, that's not going to happen. And since there was no response filed to that.
Objection.
The court
Again, how
doesn't
many
have
times
it
we
in
got to go
front
over
of
that?
All right, she's just telling the court that because, not that you had to file a response.
But we've
but
already
because
stated
you
that the
didn't, I
dismissal,
don't have the definition of this corporation.
we already agreed, and you had her agree, Your Honor, that the dismissal was a response, and she keeps insisting that there was no response.
I'm not silencing Mr. Benz. He had every opportunity to file whatever he wanted to file. I'm just telling the court why I'm including it.
Okay, so I'm gonna move on. Standing, you want me to read your
Yes.
argument with regard
And
to standing? What
the
is the
fact
second?
That stated on this complaint, it says that the lease is between the plaintiff and Ms. Coleman, when in fact, it's GNCS.
All right, I will pay
Can we
attention to that.
respond to that portion, Your Honor?
Yes.
What Ms. Cotton is failing to note is that the legal aid routinely in here every day argues that it has to be the PVA owner of record listed as the plaintiff or the party in the lease. The GNS, or whatever, I forget its whole acronym, is the successor in interest to S Impact. The original lease was with GNS, and they just had a Scrivener error and have not changed the name of the leaseholder or the owner in the lease agreement. But it's the successor interest, the property switched to S Impact, which is the individual entity, which is the owner of record at the time the notices were sent and the petition was filed. Therefore, under the real party of interest, they had to be listed as the entity. Because otherwise, if we had listed GNS, Ms. Cotton would have been in here arguing no, the real party of interest wasn't named, demanding a dismissal.
Okay.
Judge, I'm not arguing that he listed the wrong plaintiff. I'm saying that he told the court in his complaint that the lease was between the plaintiff and the defendant.
And as a matter of
And there
contract
was
law,
No
it is
explanation.
because of the successor interest doctrine.
It would have been an argument we would have made at court. It certainly would have been something that could have been written.
All right, duly noted. Let's move on to the next matter.
The notice letter that I admitted to the court, and you gave me my copy back. The two other most common defenses in the court: improper notice and waiver, Judge. If you look at the front of this notice, which is referenced on the face of the complaint, it states 3 payments were made on October 31st in the amount of totaling $3,300. This is the same date that this notice was issued to my client, October 31st. The date of acceptance of the payment is down there in the bottom, and the date of the letter is October 31st. That date is also referenced on the face of the complaint. At the time of notice, under the waiver statute, KRS 383-675, acceptance of rent with knowledge of a default by the tenant or acceptance of performance by him that varies from the terms of the rental agreement constitutes a waiver of the landlord's right to terminate the rental agreement for that breach. The
Objection,
same
Your Honor.
day that they took
Wait a
money.
minute, pause real quick.
She is not.
Is it relevant?
Articulate-
What's your
she's not
nature of your
articulating
objection?
The law correctly on this issue.
Can I
She's-
finish
she-
before I
Okay,
respond?
just tell me
Yeah.
what your objection is. Is it,
First of all, I believe this whole argument she's making is irrelevant. Second of all, I believe that she's factually misstating the law.
okay, all right, so I'm gonna allow her to finish, and then if you want to tell the court, is it addressed in your response? Your
This
response
particular
is to
issue,
this argument?
This particular, probably not, because it's not relevant, but I will be happy to file the 10-page response we have on this issue that gets sent to legal aid every time they make it.
Okay, well, please allow Ms. Cotton to finish. Okay, go ahead.
Reading directly from the statute, Judge, acceptance of rent with knowledge of a default. It constitutes a waiver of the landlord's right to terminate the rental agreement for that breach. On October 31st, 2025, the date of this letter, they knew that Ms. Coleman owed $630. That's the same amount that they're alleging in their complaint, which they filed, $630. They accepted money on October 31st. They were fully aware of that breach, and they sought to file this complaint to evict her on a breach that they were well aware of when they took money on the same day.
The entire fallacy of that argument is that breach phrase. That breach would have been referring to a prior notice or a prior file for a different amount. When you send a new notice, you create a new cure period, and that breach cannot occur until the expiration of that cure period. The argument that Ms. Cotton and legal aid continue to try to make is that the acceptance of a partial payment forever waives the right to evict for any of the prior dollars. That argument is bupkis, because when you read the statute and you read the appellate opinions, it clearly says they're talking about notice, and the notice creates the event to cure, and only at the end of the event to cure can there be the breach, and it's for that breach. Therefore, the breach is specific to the notice. In this instance, the notice was dated after the payments were made, as it reflects in the dollar amount. Therefore, that breach didn't occur until the expiration of the 7 days thereafter. Therefore, there was no waiver because the waiver cure period had not expired, and the breach did not exist until after the end of the 7 days.
I'll be short and say we disagree on the law, and that they took money the same day they knew that the $630 was owed. And that is,
I understand
And
that. I understand, and I hear
Well,
both of
to
you.
respond to that, Your Honor, if we take Ms. Cotton's argument to its face, no landlord will ever accept a partial payment again, because you're then forever waiving the right to evict tenants for that remaining balance. Furthermore, no Section 8 landlord will stay in Section 8 because they wouldn't be able to receive.
objection.
I get to make my argument, Ms.
Wait a minute, I
Cotton.
get to hear her objection, though. What is your objection?
He's hypothesizing about other things that don't have anything to do with Miss Coleman. Miss Coleman paid $3,300 on 1031, and they gave her a notice and demand to evict her for the same amount that's on the notice letter the day they took the money. It's the same day.
I'm allowed to explain
Hold
the waiver
on,
theory.
but you are hypothesizing, saying
I'm not
that if I make a
hypothesizing.
ruling on this particular issue, that nobody's ever going to take a partial payment, that Section 8 will not do it. So you're saying what you probably believe will happen.
I tell you, I represent
Let's
over
keep it to Ms.
I tell you, I
Coleman.
represent over 40% of the landlords in this city, including Ms. Coleman's, and what I'm stating is exactly what those landlords will do if the court were to interpret Ms. Cotton's understanding of waiver correctly.
Okay.
Because that will be the legal advice I give them.
All right, I understand. All right, is there anything else?
A quick review of this notice letter by any minor experienced attorney.
Objection. Now she wants to make
This is
disparaging
Ms.
comments.
argument.
Miss, So, Mr. Benz, can I ask you, may I ask you, why is it fair for you to make disparaging comments all afternoon and then she makes one and
She's
you're
made
offended
several.
by it?
I'm offended by this whole motion.
I don't want anybody to make disparaging comments in my courtroom.
I'm offended by
I
this.
don't think it's necessary. So let's refrain on both sides because that was disparaging, but
But to
I
answer-
promise you, you've got her beat on the
But
disparaging
to
remarks.
answer your question, Your Honor, I'm offended by this whole motion. I think it's bush.
I didn't ask the question.
You
whether
said, you
were
said, why did
offended.
I think I could make disparaging comments and object when she does?
It's clear that you have made it very crystal clear that you're offended by this filing of this motion. Can we please proceed? I have a room full of people. Please, let's respect the other folks in the room. Yes.
I'm asking this court to hold the wrong law firm responsible for filing this complaint when a quick review of the notice letter and then the lease and the reinstatement fee that's listed on here is not in the lease. It's not. And it's on this notice letter. And I believe that a cursory review of the facts prior to filing a complaint of eviction against someone is the responsibility of both LREI and the wrong law firm. And so I'm asking the court for CR 11 sanctions because Ms. Coleman has been put through this whole thing when there was no right to file in our opinion, no right to file in the first place. And I would like the court to hear her statement on how this has affected her. And that will be almost everything.
First of all, I don't think Ms. Coleman's been adversely affected by this proceeding. She's been through 25 prior evictions in the last 13 years,
Objection, Judge.
including over 10.
Objection has been made and you attempted to enter that earlier.
It's in my written response as well.
All right, but that's
So it's already up the record.
also disparaging. That's also disparaging.
Just because there's been previous evictions doesn't mean that this one hasn't negatively impacted her.
All right. So,
But-
you're still, hold on. I want to hear what she has to say.
And Judge, I would request that Mr. Benz not interrupt Ms. Coleman and allow her to complete her statement.
I'm sorry, Your Honor. I get the right to object to anything at the time. I don't have to honor Ms. Cotton's request.
All right,
Since
Mr.
she
Benz,
didn't honor me
let me
earlier.
just say this. You said you're going to ask her how she has been affected, I guess both either financially, mentally, physically, spiritually. And so I will just,
What's the relevancy?
I will just caution you, you're questioning relevancy and I'll have Ms. Cotton explain, but I will caution you that she's just speaking her personal, how this has affected her. I will just caution you to be kind when you are making your objections to someone who's just speaking from the heart. I presume she's just telling us how she's been affected. Ms. Cotton, will you respond as to the relevancy of why the court needs to hear how Ms. Coleman has been affected by this filing?
A request for sanctions in and of itself is asking the court to punish the plaintiff and their attorney for acting.
Right.
And so it's important for the court to hear how that action has impacted my client personally.
So you believe that this will impact my decision maybe as to number one, sanction, and then two, what kind of sanction?
Yes, and I think it's important that the court be able to rely on these complaints that are filed by plaintiffs. And that's the purpose of CR 11 existing at all, so that we don't get frivolous filings.
Objection.
Objection noted.
And so I think it's important for the court to hear how it impacts Ms. Coleman.
All right, I would like to hear in criminal court, it'd be called an impact
Before
statement.
we get to her, Ms. Coleman's statement, can I respond to Ms. Cotton's?
The use of the word frivolous that you've used several times
I'm talking
today.
about her entire argument that we didn't do a reasonable review of the documents.
I'm still
Yes,
presenting
I
my
will allow
motion.
you to defend, sir. Absolutely. I always allow to defend, but right now she's still presenting. Ma'am, please answer the question. I believe Ms. Cotton wants you to, I don't know if you have questions that you're going to ask or whether she's going to give a narrative, but we now want to find out your impact statement. Okay, Ms. Cotton?
How did the filing of this complaint affect you, Dickie?
I am so clueless about what's going on. I've never seen anything like this in my entire
I have
life.
not either.
I have been in this house 16 years. But I just didn't move in. I've been here 16 years. I've never had this much trouble until this company bought out my old company, Ramey and Associates.
Objection
I went
relevant, Your
from-
Honor. It's been motion to strike
I went-
because she's been under this particular landlord for like 7 years.
All right, well, maybe it's been 7 years, so objection noted. Can you be, has it
And
been
maybe-
7 years since
It
these
could
folks
be
have
for the
been?
landlord, but
Okay.
I'm talking about the company I deal with.
Okay,
Like I deal with
can you
LRE
be a little
and
more
prior-
specific? What
and
company
prior to
are you
that, I
referring?
was-
Hold on,
and prior
hold
to
on, hold
that-
on. I'm asking questions.
Yes, ma'am.
Because he's saying the company changed 7 years ago, but she's saying who she's dealing with. So when you say the company, if you could say either the name or the
Okay.
person you're dealing with, the
Before-
more information, the
before
better as far as details.
Yes, ma'am.
Okay, all right.
LREI, I was dealing with Raymond Associates. I have no idea who actually owned the property. I'm just talking about as companies.
And can you tell me what you mean by dealing with, like who you
As
send
far
your
as-
payments to?
Yes, ma'am.
or-
Who when I was late or who I sent my payments to, like I don't know who the actual owner of the property. I've never known that.
And how did the filing of this complaint impact you personally?
So, like I said, I've since this company has taken them over, I have went from $775 to $1,100 in like less than a year's time.
But can you talk about
But
when you went
with
to
this-
No, listen to your attorney. She's trying
Can
to
you talk
guide
about-
you in the right direction, okay?
Talk about
So
October.
answer the question she asked
Okay.
you, okay?
So we had the court. They gave me the 7 days. They asked would they accept
I'm
my
gonna
money?
interrupt you and I'm
And
gonna,
so when
She's
gonna
going to
interrupt
interrupt
you.
you,
I'm gonna help
ma'am.
you.
She's going to guide you. She knows the
Okay.
information that the court needs to hear.
Okay.
Do you understand?
yes,
October 31st, you went and paid $3,300 to them.
yes.
And what was told to you?
They were told that everything would be dropped. I made an arrangement with him.
Objection, hearsay.
I made an
Wait a minute, there's been an objection.
okay.
And I'm a little curious also is when you say they told me everything.
Okay, that's-
Oh, but that-
Okay.
I know you're anxious to talk. Okay, so are you familiar? Do you watch court TV and do you know what hearsay is?
No, ma'am.
You do not. So you can't talk, you can't say what somebody else said that's not in this room.
Okay.
That's called hearsay.
Okay.
So again, your attorney's gonna try to direct you to get the information without you saying something inappropriate.
Okay.
But when you say something like they told me it would be dropped, I have no idea what that means. Do you understand what I'm saying? So let Miss Cotton direct you. Miss Cotton?
Ms. Coleman, just tell them how you felt when you found out there was a new eviction filed after you'd paid the $3,300. How did you feel?
I felt like I had been kicked in my gut because LRE said that everything was going.
Ah, hearsay.
Okay.
We don't have anybody from
Okay.
there.
I was under the impression that everything was going to be dropped once they took.
What do you mean by everything dropped? What's dropped? What's going to be dropped? What's
Yes.
everything? You
the
see what I'm
court-
saying? What
the
is
court-
that?
The court eviction.
The court eviction. See what I'm
Yes, ma'am.
saying? You got to fill in the gaps. You
Yes, ma'am.
believe that the court eviction was
Mhm.
going to be dropped.
Yes.
Okay.
And
Did
I had arrangements to pay the additional 600 the end of that week,
And let me
which
interrupt
was
you.
left.
Did
but
you,
then I
let
got
me
to know
interrupt
Let
you.
her
Let me
interrupt
Let me
you.
interrupt you. Did you know that the judgment from the previous action was still in place
No.
until you called legal aid?
Objection
No.
irrelevant.
No.
That's all.
All right, objection noted. All right, now, again, don't add any extra information or any facts or anything. Mr. Benz, do you have a question for Ms. Cole?
Ms. Coleman, how many times has LREI filed to evict you?
Objection relevance.
I'm gonna allow it
I'm not quite sure.
Would it,
approximately. Or he's gonna, go ahead with your question.
would it surprise you that it's over 10 times?
Actually, not at the way they run things now.
How many times did Ramey and Associates file to evict you?
Maybe 3.
That's totally irrelevant. Objection.
She brought up
Ramey and Associates
how
is not a
they-
party to this
she
action.
brought up and opened the door when she said how good of a landlord they were to deal with.
She opened the door. I'm gonna
Would it
allow
surprise you that
it.
that was 13 times?
In 16 years, but maybe not.
So would it surprise you that you've been evicted or filed to have an eviction against you 26 times since 2013?
No, probably not.
Would you categorize yourself as a tenant who routinely falls behind on rent and then has to make attempts to pay up as court dates approach?
What this one does that make as long as I pay?
You don't get to ask him questions.
Okay. So what was the question again?
Would you categorize yourself as a tenant who routinely has difficulties keeping up with your payments and falls behind and then has to pay up as a court date approaches?
No,
Would it surprise you to learn that LREI has obtained multiple judgments over you in the last several years, to which you have either came in and paid after the fact and asked them to set it aside, or paid after the fact and didn't? And I think last I counted, it was at least 3 times in the last 2 years.
what you mean and didn't? Explain that.
That you either asked them to set it aside the judgment after you paid after they obtained it, or in the last instance in October, you didn't ask them to do that.
Okay, this last one I didn't, because I thought I was taken care of.
And are you currently over 5 months behind in rent?
Yes.
And Ms. Cotton is asking for sanctions to punish LREI. We heard you admit earlier that you knew you still owed them $600 and thought you had made arrangements to pay that. Is that correct?
I did make arrangements. I didn't.
And did you pay it?
No, because then I received a notice that they had filed.
And you didn't pay within the 7 days of the notice?
No, because it was supposed to go to court, and then the court was canceled because of weather issues.
So you received the notice shortly after October 31st. You originally said you were going to get that $600 paid in a week, and then you're now saying you weren't going to pay until court.
No, I didn't say I wasn't gonna pay the court. I said I got the notice, and the gentleman I had been dealing with said, wait till we go to court. So he didn't.
I know
normally they
that's
would-
hearsay. I know it's hearsay. He's gonna object because that's hearsay.
That's fine.
He's not here to say whether he said
That's
that or
fine.
not.
I have
Okay.
emails that I should have brought with me that state that as well. That I was talking to Ms. Reed.
Have you been financially impacted by this filing in any way?
Yes,
How?
I have. Like now, I'm missing work, and I'm sitting here.
In any other manner?
No,
What kind of impact other than your eviction record has this filing had upon you?
say it one more time.
What type of impact or effect has this filing had on you other than adding another filing to your eviction record?
I mean, I'm gonna have trouble trying to find another place if it be the case. But I've had agencies that have tried to help me, and the company has refused money, so it's not like I haven't tried to pay. So
Are you aware that they do not have to accept assistance?
I am.
And you're aware they don't have to accept payment after the 7 days cure period?
I am.
And would it have been imperative upon you to have cured within that 7 days?
Yes, and I've tried.
And a minute ago, as you said, you agree that you're over 5 months behind. And you're there.
Asked and answered.
Oh, she did answer. I believe she said that.
And the only financial impact you're stating is your lost wages for today?
Well, I've had, every time I have to come to court, I have lost wages. But it's not like I don't have the money. I have the money, but since all of this has spiraled out of control, I have money.
Anything else?
The lost wages is the only impact other than you're stating that this may cause difficulty for you to find a place to rent.
I answered already. Yes,
All right. And would you agree that the other 24 evictions on your record would also have an impact that are negatively on your ability to find a place to rent?
and I had no knowledge that that's how it was done. I didn't know they were on there.
So let me re-ask, yes or no, would you agree that the 24 other eviction filings would have a negative impact on your ability to rent at other properties?
Of course,
So therefore, this impact of this one particular filing would not be the sole reason that you wouldn't be able to find future housing, given that there's 24 other filings with it.
yes.
I'm done.
Right, any redirect?
You said earlier that you've lived here for 16 years. and I guess tell the court, how is it that you're still here if they keep filing these evictions?
So that's what I'm saying. I didn't know that would have to sanction or ask them to be removed. I figured once money was paid, then things moved on.
And
Didn't
you've
know
lived
any-
there continuously for 16 years.
Yes,
And they've repeatedly filed evictions against you, but you remain in the property.
yes.
That's one.
I like the redirect,
Recross.
recross, yeah. Ms. Coleman, is the reason you've been able to remain in the property is because each and every time until those times you'd subsequently paid the rent?
Say it one more time.
Is the reason you've been able to remain in the property is in all these other instances, other than this pending case, you have subsequently paid the rent and made the landlord whole?
Yes.
I think we now know why she's got to stay.
And let's put on the record, this case is dismissed. You do understand that, right? I want to make sure you understand.
Yes.
But when you said something about finding somewhere else to stay, I wanted this is dismissed, this action.
Okay.
Okay.
Thank you, Judge.
All right, very good. Thank you. Anything else for the court to hear?
Judge, at the previous hearing, Mr. Benz 6 times accused me of bad faith when I requested a hearing based on notice and waiver, and substantive defenses. He 3 times threatened sanctions against me because I requested a hearing to present my defenses to the court. That is relevant, and I would request that the court go back and review the first sitting of the case. And if the court doesn't have access to that, I do have the video provided by
Objection, she's not provided us a copy of the video, so she can't.
Mr. Benz was present.
Again,
that
Your Honor,
hearing.
she cannot enter that.
I'll have it
video.
ordered. I'll have it ordered. Do you have the date and time,
Yes.
like any markers that would help me, and I'll have it ordered.
Objection, Your Honor, she's not provided us a written copy of this
All right,
argument.
she was getting ready to give that to me. So
February 19th, 2026. And this was on the 10 o'clock docket.
And let's review, Your Honor. It's customary for this defense counsel to state their reasons for requesting a hearing. Ms. Cotton refused each and every time and only used buzzwords. She would notice, waiver, substantive defenses. That was all she would ever state. It's also customary for legal aid attorneys and other defense counsels to agree voluntarily to file their arguments or something before court. So the court has them to consider, and the plaintiff's attorney has the ability to respond in order not to waste court's time if there's some form of agreement. Who refused to do that? Ms. Cotton. She even refused to do it when you suggested it, and you had to make it in order for her to do what is customary and normal for every other attorney in this court. And what did she do? Because you required her to do her job, she had a tantrum and is demanding sanctions. Let's go back to review her claims that we didn't substantively do a reasonable review.
okay, wait a minute, pause. She's asked to respond to the allegations that you just made.
Your Honor, the burden of proof in eviction court is on the plaintiff. I don't have any obligation to file a written response, to file an answer, to file a motion to dismiss. And it's just like I earlier stated, at one glance at this notice letter, I noticed several
Objection, she's
defenses.
going right back to the same argument you told her not to do earlier. When you told her, when she was making comments, that junior attorney would have been able to do that, she's trying to backdoor that
Oh, I
again.
asked her not to make disparaging statements, just like I
She's
asked you.
about to disparage
I did
again.
not say
I'm about
not to
to-
bring up the proof. I disagree, Mr. Benz, with that characterization. I said, please don't make disparaging statements. I asked both of you all, but she's going back to,
It's,
I believe she's telling me how this is not bad faith. Is that where we're headed, where
This
you're
is not-
telling me what your filing
it
was
was not
based
bad
on?
faith, Judge. It resulted in a dismissal, and I honored the court's request with respect. And I'm willing to honor the court's requirement, but not Mr. Benz's. Mr. Benz doesn't control this courtroom. The burden of proof is on the plaintiff to prove that Ms. Coleman was forcibly detaining the property. I could have shown up here at my hearing date and made my defenses. Instead, I had to write out a brief for the court, and yes, I did that. And yes, I do think it's because Mr. Benz accused me repeatedly of bad faith and threatened CR 11 sanctions. And it was over 8 minutes that he objected to the hearing. And that is why the court asked me to file it out of a response to this reaction that he had to a request for a hearing.
And I
And-
recall all of it very well. And it really was based on the fact that, number one, generally defenses are at least enumerated. So because I like to make notes as well. And Mr. Benz did say, Your Honor, we need something that we can respond to. I'm sorry, I didn't mean for you to have to do an 8 or 10 page brief. That's not what I was asking for. But I did want I wanted plaintiffs to be able to know the defenses so that they could respond or look into the issues. So I apologize.
There's no apology required from the court. I do believe that an apology probably should come from the plaintiff in this case.
Objection.
But I will say, Judge, that Ms. Coleman has had an opportunity to discuss how this impacted her. And I will
Yes.
just say, this case has greatly impacted me. It has,
Relevance, objection.
it is,
This is regarding a sanctions motion. So
It is-
I think she's explaining to the court why she
How it
filed the
impacted
motion.
an attorney? How's that relevant to
It-
the
it
award?
Well,
is-
can I hear what she's gonna say? And please reserve, I'm noting your objection, but I'm interested to hear.
it is not the job of any defendant in this court to provide the plaintiff with the reasons why a case should be dismissed. That happens at the hearing. They have to prove their case. Many times that can't even be done before a defense is presented. He keeps saying that I'm asking for sanctions because I had to do my job. In this case, I had to do everything. And then he just
Objection.
filed his motion
Objection
to
noted.
dismiss, and he's done.
Objection noted.
First of all, Ms. Cotton has failed to acknowledge that the reason we require anything from writing from her and if we ask for that is because of Ms. Cotton's prior instances of demanding trials, demanding hearings, and then not being able to back up her arguments.
Objection.
Objection, that's disparaging,
Ms.
Mr.
Cotton also
Ben.
fails
Your Honor,
to
can I
acknowledge.
state my objection?
Yes,
The court can go back and look at the court's record of cases between myself and Mr. Benz. They either end in an agreement that's favorable to my client or a dismissal.
They do
And
not.
that is the
Mr.
court's
Benz, you're
record.
interrupting.
That's the court's record.
I think the court record will also show that Ms. Cotton has lost a large number of those contested cases.
Okay, I don't keep up with statistics on who won and who lost. We all want the best outcome for all the parties. Mr. Benz, do you have any other response to the sanctions?
I have several.
Okay, and can we remember, it is now 3:30 and I have, I think, 8 other hearings, so can we
Right, so Ms.
please?
Cotton's failing to mention that part of this is brought upon by her own actions when she demanded frivolous sanctions in a case here
Mr.
in early
Benz, did we
February.
just not say that we should not probably, either party, don't use the term frivolous unless you can prove to me that they are frivolous? I consider that to be insulting.
There was an
And-
agreed order entered in that case that was favorable to my client after I filed that CR 11 sanctions motion, which Mr. Benz and I agreed
Your Honor,
to
why is she getting to interrupt me when it was my turn to talk?
because
And she
he,
didn't make an
Okay,
objection.
please don't use the term frivolous anymore. I'm gonna ask you not
that's a
to.
part of the court's
that-
record too.
That is insulting. It's indicating bad faith, and I don't believe you have been able to show that to the
I also
court.
believe that Ms. Cotton files these sanction motions in an attempt to extort settlement agreement.
Mr.
And I
Benz,
can prove this one.
extortion?
I can prove this one.
Your
by
Honor,
her own-
negotiations cannot be entered before this court, and that is what he's attempting to do. Whatever offer was made to Mr. Benz to get rid of this CR 11 motion, that's between counsel. And it should not be presented as evidence or opinion or thoughts from Mr. Benz.
Mr. Benz, I don't want to hear any kind of, I don't think that's appropriate, and I don't think
So
stating that
let's-
someone is extorting you, sir, that is very, no, that's not appropriate, sir. That is not.
So let's review Ms. Cotton's argument that we didn't make a reasonable review. In Ms. Cotton's world, I'm supposed to do her job for her and go through every word of the lease, every entry on the ledger going back multiple years, going through everything and figuring out if there's any possible defenses or flaws in a filing. That's not the case. We're required to make a reasonable review of the documents. In this instance, we reviewed the lease. The lease exists that said who the parties were, what the rent was, what the duration of the lease was, items indicative of a lease. We reviewed the ledger. The ledger showed a balance that matched what was in the notice letter. We reviewed the ledger and saw where there were the payments, and then there was a new notice sent. That was reasonable. We reviewed the notice letter. It had the correct ledger balance. It had a date. It had the required wording for a 7-day notice letter. It was sent certified mail. Ms. Cotton, in her notice of offenses, tries to make some arguments that we had extorted a bunch of illegal attorney fees going back a couple years and we should have to repay all of those back. It's not reasonable to expect somebody to go back through multiple years of ledger entries to see if there was any charge that may or may not have been appropriate. Because what you're looking at is what's happened since the last filing or what's being alleged in the current petition. Our position is that when we reviewed the lease, we saw the parties, we saw the address was correct, we saw the duration, we saw the rent amount, we saw the late fees, all this stuff matched what we were filing in the petition. That's reasonable. That we reviewed the ledger, that we see, all right, the ledger says that they made payments on this date that led the balance of $630. That is what's in the notice letter. That's reasonable. To expect us to do her job and come up with every possible defense and then decline filing if we find anything is not reasonable. In this instance, Ms. Cotton is trying to hold plaintiff and plaintiff's counsel to an unreasonable standard, that they should take this large in-depth review of every single item. Furthermore, when I sit back and I go through all of it and I look at Ms. Cotton's notice of the defenses, when she starts talking about court fees and that we were illegally charging all these fees, Ms. Cotton alleges that it's illegal for the landlord to charge $141.50 in a court fee. That she said that was an unlawful thing. $141.50 is exactly what a forcible detainer cost through electronic filing prior to the changes of the court fees on November 1st of last year. I believe KRS 383 allows us to impose the court cost on to a tenant. And furthermore, she wants to talk about reinstatement fees. That is part of the lease agreement. It's in the addendum that Ms. Cotton filed. The reason we dismissed this case is Ms. Cotton raised the point that she could have done it via an email or a phone call versus an 8-page brief, but she chooses not to communicate with my office. She raised the point that the landlord charged $300 when the lease said it should have been $250. We looked at that. Okay, that's right. We will dismiss. Where was that not at? That was like on page 17 of an 18-page lease. It's unreasonable to expect us to read every word of an 18-page lease to see if $1 doesn't match something that's on the ledger. That's the burden of the defense attorney if they want to challenge what we thought was correct. She says they don't have to prove anything. That's not true. They have to prove their defenses. We asked her to enumerate her defenses at the call of the case. She gave us buzzwords. She wouldn't provide any specifics. Who knows why? We asked for her, as customary, to put her notices in filing so we have a chance to respond. Ms. Cotton here just a few minutes ago said she doesn't have to do that. She is allowed to do trial by ambush, which is frowned upon in this court and in this practice generally. Everybody else gladly exchanges documents. Why was it such a burden on Ms. Cotton this time to enumerate any defenses or to put them in writing as requested in requiring a court order? I have no clue. I will note that this has happened before, where the courts had to order Ms. Cotton to make these filings where she's made the same argument she's not required to. But in the same vein, I'm not required to file any of my exhibits or anything in advance to give them a clue into my case. I'm allowed just to show up into court and play trial by ambush, but I don't believe that's fair or practical because I believe they put everybody's cards on the table, and if we see a flaw, we can dismiss it and save everybody time and energy. Ms. Cotton is now asking for like $6,000 in attorney fees. First of all, I can't for the life of me fathom what took her 24 hours to do this, because quite frankly, an experienced attorney she claims to be should have been able to do this in a lot less.
That she claims to be. Is she an experienced attorney, Mr. Bean?
She claims to have 15+ years of experience doing this.
Do you think that she's being false with the court?
I do not know how many years she's been
Okay.
practicing.
All right, again, let's try to stop with the disparaging comments.
But
Okay, so you do not believe that if there were to be sanctions, you're telling the court, number one, you do not believe this should have taken 24 hours and therefore the $6,000 should not be.
I believe that's a preposterous number, and I would request a specific hearing on that dollar amount if we go forward with sanctions. My argument is we didn't violate CR 11. We took reasonable review of the documents. It's stated in our response where we discussed this. The steps we did to review and how it was reasonable, and her position is unreasonable. We believe, as we stated earlier, in our inference from her own writing, that she's demanding the sanctions because she was required to file the defense. That, and I can go get to the source and prove it if I need to, is retaliation. Retaliatory conduct such as that is in violation of CR 11. Because CR 11 says you're not allowed to file motions for improper purposes, such as to harass the other party or to increase the cost of litigation. Filing a motion demanding sanctions such as this is meant to harass us and to increase our cost of litigation, both in violation of CR 11. As I said in my response, I would encourage the court not to sanction Ms. Cotton for that degree, but just to remind her to be more cautious when she files client information into the record going forward, even though the court would be well within its right to sanction her for that violation as well. I find this entire motion to be insulting that we didn't do a due diligence to go forward. We routinely reject filings from landlords every single day when we spot errors. They only go forward if after doing a reasonable review, we do not see any errors and that we see the base requirements are met. To infer otherwise is insulting, it's derogatory, and it's simply not true, and she cannot prove otherwise.
Judge, I'll rest on my written
All
motion.
right, very good. Resting, Mr. Benz? Very good. Thank you both. I will set this for findings. We've agreed on the ceiling, so we won't need to review that again. But with regarding the sanctions, Ms. Sierra, are you still here? We will be, what did it say? My next day is 23? 3/23 at 1 o'clock.